SJC-11486, Commonwealth v. Daniel D. Almeida.
Yes, counsel. Good morning.
Good morning, Your Honor. May it please the court. My name is Harry Miles. I represent Mr. Almeida in this case, and I submit that the trial judge's ruling that Mr. Almeida is a sexually dangerous person should be reversed and either a required finding be entered or the matter remanded. Mr. Almeida was 40 years old in 2010 when he was committed for 1 day to life to the Massachusetts Treatment Center, officially known by statute as the Nemanket Correctional Facility. Mr. Almeida has never been diagnosed as a pedophile. He's never been diagnosed as having antisocial personality disorder, and he's never been diagnosed as suffering from a condition known as paraphilia NOS, which would lead one to believe that he could commit contact offenses. His only diagnoses are exhibitionism and voyeurism, neither of which, according to the experts that the trial judge credited, allow a prediction that he will commit any contact offenses in the future. Although, since exhibitionism in particular is a fairly intractable condition, the expectation is that he will sexually offend in the future if not confined to a secure facility. I would submit that the Commonwealth's brief essentially didn't deal with this case. The Commonwealth talks about luring, stalking, things of that nature. That isn't this case. The trial judge explicitly found that neither the index offense nor previous offenses had characteristics of anything other than exhibitionism or voyeurism. The trial judge explicitly found that the index offense, which involved breaking and entering into an apartment and exposure to the inhabitant after taking the inhabitant's kid and putting the baby on the floor, was not the assault and battery on the baby was not a sexually motivated offense, and that the circumstances of that offense, although the trial judge found was an escalation of previous behavior, was an outlier and not indicative of future behavior. So in this case, we have an individual who is found by the trial judge not to be a danger in the future of causing sexual contact against any victim. Then the appeals court, I would submit, got it wrong when the appeals court focused on the reaction of the victim as the sine qua non of menace. I would submit, and I understand that this court has asked Mr. Fennell a number of questions on that issue, that the appropriate focus in these cases on the issue of menace is on the predicted behavior of the offender and not upon the variable behavior of a victim. Because if one focuses on the victim, then I would submit we move into the constitutional dimension of trying somebody on a vagary, a possibility, a uniqueness, a unique characteristic controlled by or inherent in the victim and not in the offender. And I would submit that these statutes focus on the behavior of the offender. The offender is committed because the offender is likely to do something which the statute defines as sexually dangerous.
Now, you say it would be as opposed to the variable reactions of the victim. Now, the Suave test is one that really deals with the reasonable, the objectively reasonable apprehension.
Exactly, and the problem that has arisen is that the objectively reasonable reaction has been taken to focus on the victim and not on an overview.
That's what the decision says, right? That it's the victim. It focuses on the victim. Does it not?
I disagree with that. I think the decision can be read to say that as one stands apart from the incident and the observer who is not part of the incident looks at the incident is judged by the predicted behavior of the offender and whether that behavior is objectively reasonably to cause fear of contact in the victim. So the particular victim should not be irrelevant to the analysis.
So you would suggest then that an offense, an exhibitionist-type offense, where the exhibitionist pursued the victim, maybe not wanting to catch up to the victim, but just pursued the victim, that, objectively speaking, would give a reasonable apprehension in the mind, or an apprehension in the mind of a reasonable victim, that they are likely to be victimized, right, by contact offense?
No, absolutely not.
Why wouldn't exhibition
Because,
plus
again,
pursuit or stalking reasonably put this apprehension?
If we're talking about stalking, we're talking about a different case.
Well, I mean,
Let
pursuing.
me use your hypothetical.
Okay.
Using your hypothetical, if the experts credited by the trial judge in the trial judge's findings say that no matter what the offender is going to do, the offender will not have cause a contact offense with the victim, then the pursuit is not a relevant criterion in the determination of menace, because
So you're completely removed from a reasonable victim.
So,
I mean, a victim, I think a reasonable person who confronts someone who's exposing themselves and then pursues them as they try to get to their house, I think that person would be quite in fear of being subject to a contact sexual
if I
offense.
might respond to that, perhaps a little obliquely, puts me in mind of Zeno's paradox. Stand the target up, shoot stand person up, shoot an arrow at the person. The arrow travels halfway to the person moves away from the arrow, then the arrow travels the next half, person moves back, then the arrow travels half the remaining distance. Zeno couldn't figure out that you had a converging series that never got there. And I'm saying that's the same thing in answer to your hypothetical. You may have pursuit. The particular person who is being pursued may be shocked, alarmed, awed.
Scared to death?
Scared to death. That's not the relevant criterion.
So you're saying, if I understand correctly, that that is a matter of logic, if all the experts say he's only reasonably likely to commit non-contact offenses, that it is logically impossible that somebody could have a reasonable apprehension of a contact offense. Is that what you're saying?
No, what I'm saying is it may be certainly practically and logically possible that a particular victim will fear a contact offense. However, it is not sufficient to bring that to the level of menace. So I think what we need.
Okay, all right.
at
So
least what I'm
menace
asking the court
has to be, menace equates with an expert saying there is a reasonable possibility of contact offenses.
And a trial judge finding that. Yes, sure. That's exactly the point.
But then why is the contact the critical focus? I mean, the same person could actually touch the victim, and that just touch them on the shoulder. That would make it a contact offense, but doesn't mean that they sexually assaulted the person. Why should contact then be the critical element? Isn't the critical element that how close the person is coming to the victim to instill a different degree of fear than the person exposing himself very far away?
No, Your Honor. I think there would have to be more, and perhaps someday I'll be in front of this court arguing one of those cases. Number one, there's got to be sexual motivation behind the touching. Otherwise, under 123A, Section 1, it's not a sex offense. It's simple assault and battery. Number two, the degree of fear goes into the definition of what menace is. So if all it is a touching that may even be sexually motivated, for example, a boyfriend stroking his girlfriend's arm, that might be a sex offense if she didn't want him to do it, but it doesn't rise to the level of menace. So what we need are, number one, a prediction in a Section 12 case that there will be a contact offense, and the contact offense, if I were to be arguing that case, I would submit, would have to be of sufficient severity to flesh out or meet the definition of menace in the statute. Otherwise, you come back to the substantive due process problem that we have with this statute. I'm almost out of time, but I would tell you, I did read People versus Stoddard, which the trial judge referred to in his opinion, California case, 1975. In 1979, California eliminated emotional injury as a possible foundation for commitment as a sexually dangerous person. And that was in People versus, I think, Bradford, which is also a California case. But that's the problem as I see it in a nutshell. Thank you very much.
Thank you, sir.
Good morning, Your Honors. Mary O'Neill for the Commonwealth. Contrary to my brother's presentation, and with all due respect to my brother, this case is simply about whether or not it was reasonable, objectively reasonable, for Ms. Santos to believe when she walked out of her shower to respond to an uncharacteristic cry from her 6-month-old baby. Was it unreasonable for her to believe when naked in her bathroom she saw a 38-year-old man staring at her? Was it unreasonable for her to believe that she was in danger of an imminent sexual crime?
Is that really the question? Because we're looking not to that crime necessarily, but to future crimes.
Well,
Are we
I
saying
think,
this is the model? If this model were likely to occur again, then clearly there would be a reasonable apprehension.
well, if I might, Your Honor, the menace piece from Suave, menace became two parts. It has its medical aspect. Well, the mental abnormality piece has its medical aspect and it has its legal aspect. And now menace, after Suave, required that the individual, reasonably be in fear of an imminent sexual crime. Now, Ms. Santos and the Commonwealth in this case, succeeded in meeting Suave, even though this case predated Suave. Now, if the court is mentioning the third element, which is the likelihood of further crimes, I don't think Suave speaks specifically to that. It may be that this court is looking to expand Suave to now require contact offenses in the imminent contact offenses or future contact offenses in the third element. But I don't believe that's what Suave found. It defined menace with assault, and it then further defined assault under the criminal law, and as I've just stated, and I'm sorry, I'll repeat for emphasis, that definition was reasonably in fear of an imminent sexual crime.
But Suave speaks that there must be a finding of a likelihood of that, not that the past offense involved that. You agree with that?
I do agree with that.
Okay.
And that would tie it.
And did Judge Roop make any finding that there was a likelihood of a contact offense or a likelihood of a non-contact offense that would meet the Suave standard?
Well, what I would say to that, it was Judge Cosgrove who was the trial judge.
Judge Cosgrove, I'm sorry.
Sure. And what I would say to that is the appeals court got it right. Did the judge specifically make a finding of a likelihood of a contact offense in the future? One, he was not required to do so at that time, and I would submit to the court he's not required to do so yet. Maybe after this case they will be, but as of this point.
So you're saying even after Suave, there's no requirement that a judge find that there's a likelihood of either a contact offense or a non-contact offense that would meet the Suave standard?
The likelihood of the contact offense that Suave finds is the likelihood of at that time was that individual, in this case Ms. Santos, under the reasonable apprehension that she was going to be sexually assaulted in some fashion imminently.
So you're saying that the Suave standard looks backwards to the previous crime as opposed to looking forward to the predicted crime?
Well, I don't think Suave, and maybe I'm reading it wrong, but I don't think Suave requires the Commonwealth to prove an imminent contact offense in the future.
Right, it clearly doesn't, but it
It's
speaks
focusing
about...
on the non-contact in the
Right.
future.
Correct. Well, we're focusing on the non-contact in this case, and what we're saying, Suave never said it had to be a contact offense, if I'm understanding.
Yes, okay,
Judge
that's clear.
Okay. So it doesn't require it.
But if it is to be a non-contact offense, it has to be a particular kind of non-contact offense.
That's true. I would agree with that.
And is there any finding, I mean, where Judge Roop says On page, I'm sorry, Judge Cosgrove, page 9, the evidence does not permit a reasonable inference as to whether the shower incident is a precursor or an outlier. How can we infer from that that Judge Cosgrove, based on that incident, made a finding that there is a likelihood of future contact or offense or a likelihood of a future non-contact offense that would be sufficient to meet the Suave standard?
He expressly, and I would go further than where you're going, Judge Gantz, he expressly stated that he could not find that there was the overwhelming evidence, I believe those were his words, the overwhelming evidence that there's going to be a non-contact offense in the future. What I'm saying to the court is, so what? I don't mean that glibly. What Suave did was say, well, that can be a very important thing, but that is not the only potential for an SDP. Suave said, if there is evidence of luring, if there is evidence of approaching, if there is evidence of children involvement, all evidence of stalking, 3 out of those 4, and arguably 4 out of those 4, were all involved with Mr. Almeida's case. The approaching.
But doesn't that go to the issue of sufficiency as opposed to the issue of whether Judge Cosgrove made that finding?
I'm not sure I understand the question, Your Honor,
The
but.
difference between whether the evidence would be legally sufficient to meet the Suave standard versus whether the judge indeed found
I
that
see
it
what you're
met
saying.
the Suave standard. And it seems that the appeals court is focusing only on the sufficiency of the evidence and doesn't speak to whether or not there was actually a finding by the trial judge that it met that standard.
Well, if, Justice Gantz, if you're requiring now, if this court is requiring now that there has to be a finding of the language of Suave, that will require remand, because in this case, Suave didn't exist. The Judge Cosgrove did not have the guidance that Suave provided. What the appeals court, through Justice Kafker, did was state that the facts of the crime itself, with Ms. Santos, the facts of the gentleman being in her bathroom, you know the facts, I don't need to repeat them ad nauseum, but those facts in and of themselves were sufficient, and he found those facts. That was sufficient for a finding that his future crimes, while being non-contact offenses, overwhelmingly, will be these types of crimes. Dr. Canones testified that his future crimes will include, they will be non-contact most likely, but they will include crimes such as this one. Dr. Rouse Ware, the QE, would not confine herself to non-contact offenses in the future. But in any event, Judge Cosgrove was not required, even with the decision in Suave, was not required to state that the non-contact, that there had to be contact offenses, nor, well, it would have been great if he had put down the non-contact offenses would be the same as this particular offense, but that finding is, that conclusion is represented in his findings and rulings as the appeals court found. I mean, if it comes down to, and I don't mean semantics, but if it comes down to he's missing a sentence because he didn't have the benefit of Suave, then he should have the opportunity to put that sentence in there. But as the appeals court found, it's not necessary to do that. He made a finding based on the facts, he made a conclusion based on the facts that he found. And when we look at this from a constitutional analysis, are those facts, is that bathroom incident sufficient to sustain substantive due process?
Right, so why doesn't that say that if it goes back to Judge Cosgrove and he says, yes, it meets the Suave standard, then it would be sufficient? Isn't that all that the appeals court decision essentially says? But it doesn't say whether Judge Cosgrove will indeed make that finding. There's reason to think he may not, based on what he said with regard to the bathroom incident.
I would have to say I don't agree with Your Honor in terms of the possibility of him saying that the bathroom incident would not rise to the level of an objective fear of imminent sexual crime, but.
No. The issue is whether it predicts that, not whether it was.
Okay. Well, with the issue in terms of whether or not it predicts it, Your Honor, as I say, the only guidance that we have, is Judge Cosgrove's decision regarding what has occurred. They can only look at what has occurred to predict what will happen. So I don't think that there is a Maginot line that says we can't look at that in order to predict this. And that's what he did. He looked at and found facts supporting that this was that this was sufficient for a sexually dangerous person finding. And I think, as the appeals court found, that would be, the Commonwealth thinks that would be sufficient in order to affirm the decision of the two QEs, the trial court judge, and the appeals court. If the court wishes, I can rest on my brief on the substantive due process piece, but if not, I can address that now, quickly.
You've got 30 seconds.
I got 30 seconds?
Yeah.
Okay. As far as the substantive due process piece goes, simply put, the Supreme Court has never required violence, it's never specifically required touching, it's required danger. And in this case, in particular with the governing offense, it would be hard, the Commonwealth would be hard-pressed to present a more dangerous situation, one in which an imminent sex crime is highly likely. Thank you, Your Honor.
Thank you, counsel.
All right. Hear ye, hear ye, hear ye. All persons have anything further to do before the Honorable, the Justices of the Supreme Judicial Court, now sitting in Boston, will sit before the Commonwealth. At present, depart and keep your attendance at this place tomorrow morning at 9 o'clock, to which time and place the sitting in this court is now adjourned. God save the Commonwealth of Massachusetts.